before the court is Kennebec 23-426. This is William Clardy et al. Versus Troy Jackson et al. See if I can get on my chair here. We are being streamed live on the web, both by video and by audio. If counsel appear to be present, and assuming you're ready to proceed, I would ask the counsel who are arguing to please introduce yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Karl Woock with Stephen Smith representing the appellants, William Clardy, Michelle Tucker, State Representatives Shelley Rudnicki and Randall Greenwood, and Respect Maine, a non-profit organization. Thank you.
Thank you.
Good afternoon, Assistant Attorney General Kimberly Patwardhan, representing Governor Mills, Senate President Jackson, and Speaker of the House Talbot Ross.
Thank you. Mr. Woock, if you're ready to proceed, we'd be happy to hear your arguments.
Thank you, and good afternoon, Madam Chief Justice, and may it please the court. As I noted, I represent the appellants in this matter, and I'll keep my opening fairly brief. The appellants are asking for two forms of rather ordinary relief from this court on appeal from the Superior Court's order granting the state's motion to dismiss. First, that this court interpret the Maine Constitution consistent with its text and its history, and to offer the courts a framework to determine whether the governor abused her power under Article 5, Part 1, Section 13 by invoking an extraordinary power where the only thing extraordinary was her open rebuke of legislative autonomy. And second, that the court distinguish legitimate legislative activity from deliberate collusion between legislative leadership and the governor to circumvent constitutionally limited powers. Appellants argue and appellants believe that to ignore the limiting language and the limiting principles explicit in the Maine Constitution is to corrupt its meaning and guts important protections against the government's abuse to the detriment of Mainers.
Counsel, I see that the green light is on. Can we go to what I think is really the threshold issue, and that is standing in this case? The plaintiffs in this case really fall into three different categories: citizens, some legislators, and then there's an organization. I don't really see any allegations in the complaint that first would give the organizational standing. Are there?
The organization is comprised of both taxpayers and sitting state representatives. So there is that, and that's a...
So the organizational standing is no different than the individual standing here, you're saying?
Right, and I believe
And why is there individual standing here?
The individual standing, I think I would want to focus on the lower hanging fruit here, which is the sitting representatives who have had their votes not to convene a special session diminished by the actions of the collective state actors that goes to the governor, as well as the legislative leadership named in the suit.
So that idea of standing then really depends on us agreeing with you that those two things are somehow related. In other words, that the legislature's ability to convene a special section is somehow related to the governor's, or the governor's ability to convene a special section is related to the legislature. I mean, the legislature can convene a special session by means of a majority vote of both parties, right?
So, right, the clause under I think it's Article 4, Part 3, Sections...
Part 3, Section 1.
Part 3, Section 1, yeah. With the consent of the majority of the members of each political party, that's correct.
Okay. And the governor can call a special session under Article 5, Part 1, Section 13.
The governor can call a special session upon an extraordinary occasion. That is correct.
Okay. Neither one is dependent on the other, though. They both have the ability to do that.
Right, and I think to answer the question, it's not necessary to necessarily agree with the appellants on both issues, although both issues are present here. You know, I mean, the reality is that we have to look at this as not so much independent actions. They are actions where the specific vote that was taken by the legislature was.
But if we, but my point being is, if the governor can convene a special session under Article 5 without regard to what the legislature does or doesn't do under Article 4 with regard to a special session, then there can't be a diminishment of the vote that you're saying.
And yet, in the facts that played out here, the specific vote of the legislature was whether or not to reconvene on April 5th, 2023, and that was rejected by the legislature. So when the governor invokes her power under extraordinary occasions to convene the legislature on that same date, and does so in concert with the legislative leadership, I do think that it collectively acts to diminish the
But the governor, I think, I know your position is that there was no extraordinary occasion. I get that. But let's assume there is. The legislature takes a vote on the call of the president and the speaker. If they don't have sufficient votes to convene a special session, the governor decides it really is an extraordinary, under anybody's view, an extraordinary occasion and convenes. I mean, you're in the same diminishment, but there's no...
I disagree in that hypothetical, because the position of the appellants is not that the governor simply cannot use the Article 5, Part 1, Section 13 power in extraordinary occasions to reconvene the legislature. That's certainly not our position.
But your standing argument about the diminishment of the quality or the value of the vote depends on that.
I don't know that it depends. Again, here we have the leadership of these two separate branches acting in concert in order to frustrate mandates of the Constitution. The mandates being that the limitation to the governor's power is that there be an extraordinary occasion. Here, the pretextual extraordinary occasion is that the legislature voted not to return to work on April 5th, 2023.
I understand that that's what you're saying is the extraordinary occasion. My point was simply that the vote that you're saying is diminished whether or not there's an extraordinary occasion under your view. Because if the legislature decides not to, if they don't have enough votes to do the special session, governor says, I'm going to call you into special session. That vote that you're claiming was diminished whether or not there are extraordinary circumstances.
And I respectfully disagree.
Or not diminished.
I respectfully disagree in the sense that what Madam Chief Justice put forward as a hypothetical is if there were different circumstances here, whether I agree or disagree with the governor's rationale for invoking her power, if there are different circumstances, it's still a diminishment. I don't see it that way. I think if it's a legitimate exercise of power.
But how does that not diminish the individual legislators' votes equally, is my point.
I suppose if there are intervening circumstances that make it necessary to convene, or appropriate to convene the legislature for a special session.
So any time a bill vetoed, does that confer standing on any legislator that voted in favor of a bill?
I suppose I don't know that I can hypothesize about too many hypotheticals, right? So the issue here...
Well, I'm trying to figure out the principle of standing, here.
Right, and the principle is that the governor in this specific instance did in fact rebuke the legislative actions.
But can I challenge you on that? I mean, the legislature voted here not to convene by consent and to adjourn sine die. That's what it voted?
Yes.
That's what happened?
Yes.
And the governor has the prerogative of calling a special session. Where's the injury? What has been deprived?
Well, so again, in the specific context of, I'm looking at the state representatives as plaintiffs, they...
I'm assuming you may have given up on the others.
I don't think that assumption is fair, Your Honor. I think that the issue of taxpayer standing might be a little more thorny, but for the purpose of this appeal, I do think that if we establish that some plaintiffs have standing.
So do you just want to stand on your briefs on those other two issues? Stand on your brief on individual and traditional and taxpayer standing?
If the court wants to grill me on that, it's fine.
Okay, no one wants to grill anybody, but I still would like an answer to what is the injury.
Right, and again, the injury here is that when you look at the totality of the circumstances and the collective actions between the legislative leadership and the governor, the invocation of the power, the governor's power, was deliberately in response to the legislative actions to vote not to convene on April 5th, 2023. Whether there's a deliberate effort by the governor to use this separate power to undermine that vote is what is alleged in the complaint, and I do view that the totality of the circumstances here put us in a different hypothetical or a different context than if there's hypothetically a new emergency or a new situation that does.
Counsel, that right, though, is not personal to these two individuals. We're talking about, this is more akin to an institutional injury as it is, as opposed to a particularized injury to these individuals, isn't it?
Well, the diminishment of their vote is injury. It is a diminishment to their right. I don't.
How is that different than the right of any other individual in that party?
Or in that legislature.
In that legislature.
I don't think that you need the full legislature to bring the cause.
So any individual legislator who feels his vote was overridden now has standing to bring a challenge to gubernatorial action?
And again, we're not asking the court to go that far. What we're asking the court to do is hold that under these particular circumstances, under the facts that are presented here, that this collusion between the legislative leadership and the governor does give rise to standing in this bespoke, tailored circumstance.
But I still want to get you, I'm still getting a handle on the injury, and you said their vote was diminished. There was a diminishment. And in response to Justice Douglas's question, if we accept your argument as a rule of law, that would give the prerogative to any legislator who had voted for a bill perhaps and vetoed to say, well, that is, the vote was diminished because the governor exercised her prerogative to veto it. I mean, here they voted, not to reconvene. They voted to adjourn, sine die. That happened. That vote was not diminished. And then the governor exercised a separate prerogative. And you want us to say that because the prerogative the governor exercised was in contravention of what the legislature did, that somehow creates an injury.
I think the difference between that hypothetical is if the governor is nice.
You got a minute.
It's 1 minute.
1 minute.
The difference with that hypothetical is that if the governor is exercising a lawful constitutional right, then in that circumstance there is no injury. So it is tethered to the idea that.
But standing in terms of particularized injury, you seem to be tying it to the outcome on the merits. Does standing depend on the outcome on the merits? In other words, there's no standing if it was constitutional, and there is standing if it wasn't?
I think there's no injury if the governor's lawfully exercising a certain veto power under Justice Meade's hypothetical. I think that in this instance, where there is a totality of actions and a collective action that does undermine the integrity of the main Constitution, that does give rise to a particularized injury under those particular circumstances presented here. And we didn't get into the merits, but maybe I'll cover that in the remaining 2 minutes.
You'll have your time for a rebuttal, your 2 minutes. And for the state actors.
Good afternoon, and may it please the court. Governor Mills lawfully convened the first special session of the Maine legislature, and Senate President Jackson and House Speaker Talbot Ross lawfully assembled the legislature upon the governor's proclamation. The governor, and only the governor, has the authority to decide what constitutes an extraordinary occasion under Article 5, Part 1, Section 13 of the Maine Constitution. The Constitution assigns that power to the governor and no one else. The governor's constitutional power to convene the legislature is also discretionary. Even if others may think the circumstances warrant or do not warrant a special session, the governor can choose to convene a special session or not. As a result, the governor's determination on when and under what circumstances to convene the legislature under Article 5, Part 1, Section 13 is final, and it cannot be invalidated through the courts. The state officer's position is consistent with the 1940 opinion of the justices, which interpreted Article 5, Part 1, Section 13. That opinion explained that the governor alone is the judge of the necessity of convening the legislature upon an extraordinary occasion, which is not subject to review. This reasoning is grounded in our constitutional separation of powers, which safeguards the independence of each branch of government within its respective sphere. The state officers are not asking the judicial branch or this court to abdicate its judicial authority or rubber stamp the state officers' positions. The court should analyze the text of the constitutional provisions at issue to determine the applicable powers of each branch of government and whether reviewing the challenged conduct of the state officers would intrude into the functions of the other branches of government. The state officers submit that in answering that question, the court should adopt the reasoning of the 1940 opinion of the justices, which honors the text of the Constitution and the separation of powers. For this court to hold otherwise would intrude into the functions of the other branches of government. It could also call into question not only the laws enacted during the first special session of the 131st legislature, but also the laws passed in numerous other special sessions. That would be a truly remarkable outcome. For these reasons, and for the reasons stated in our brief, we ask that the court affirm the dismissal of the Clardy appellant's amended complaint. I'd like to address an issue that came up in the appellant's reply brief, where they suggested that the state officers deliberately circumvented the constitutional constraints and the will of the legislature. That argument assumes that the legislature and the individual legislators were powerless to act. The legislature, if it did not want to be convened in special session, could have adjourned. And similarly, any legislator... Yes.
I see that the green light is on. To be technical, they still had to convene, but they could have immediately adjourned.
That's correct.
Okay.
Yes.
If the governor has the sole and exclusive prerogative and discretion to determine what constitutes an extraordinary occasion, that means, what does extraordinary mean? Under your argument, or under your interpretation, extraordinary really means any. The governor can reconvene upon any occasion, because she could say, well, there's a problem with a leak in my office. That's an extraordinary occasion, and I'm going to reconvene the legislature. You're saying that can't be reviewed, can't be examined by any other body?
I don't think that's what we're saying. I think what we're saying is that decision can't be reviewed by the judicial branch. The legislature, once called into a session, could, of course, immediately adjourn. That's the check on the governor's power to convene a special session of the legislature.
Counsel, doesn't the very notion of judicial review imply some intrusion on another branch?
That's an interesting question. I think that our established separation of powers and established case law and our history and traditions establish that the judicial branch does review laws that have been applied in certain circumstances. That is the role of the judicial branch, to say what the law is, the law that is enacted by the legislature, and then it is interpreted by the judicial branch.
And the Constitution.
Yes, but not if it intrudes within the other branches of government and the roles that are specifically assigned to them and to no other branch of government. As an example, the governor and the legislature can no more tell this court what constitutes a solemn occasion than this court should tell the governor what constitutes an extraordinary occasion.
Well, let me direct you to Article 1, Section 21, which is the takings clause. And you have to have an exigent circumstance in order to take property. Exigent circumstance sounds a lot like an extraordinary occasion. And what we said about our standard of review there, we said the question of determining exigency has long been considered to be a political decision for the legislature to make, free from judicial review, unless it can be said that there is no rational basis upon which exigency could be found. So aren't we saying that even the public exigency requires some judicial review, however deferential?
I think the difference is that Article 1, Section 21 is a statement of rights, as opposed to Article 5, Section 1, Part 1, Section 13, which assigns a particular responsibility to an individual actor within our constitutional structure. So I distinguish it on that basis because the Constitution assigns that discretion to the governor and no other person.
What is an extraordinary occasion?
In this particular circumstance, it was the unfinished business, numerous appointments, and budget issues that had been left unfinished at the end of the first regular session.
The business has to be extraordinary to convene?
No,
first?
it is whatever that particular governor determines to be an extraordinary occasion.
Is that without limit?
Yes.
Can I serve a possible interpretation? Could extraordinary simply mean it's not a regular session, not a special session? It's extraordinary. That it has nothing to do with the magnitude of the business, but it's simply the governor has to say, well, by law, we have a regular session, special session, but I want to call a session here. That extraordinary really just means not one of the preordained sessions. I mean, it's an argument that would favor your position, but does it hold water?
It is an argument that would favor our position, but I don't think that's the argument that we're making. The argument that we're making is that the governor gets to determine what constitutes an extraordinary occasion. The circumstances that were presented to Governor Mills might not be an extraordinary occasion in the judgment of a different governor, but that governor would get to decide if those circumstances constitute an extraordinary occasion or not.
Well, when it comes to reviewability, Justice Connors raised the issue of exigent circumstances for purposes of taking. The legislature may determine, and in fact does determine on a regular basis, that legislation should be enacted as emergency legislation. Is that a reviewable decision?
Yep, yes, those implicates the court's line of cases in Morris v. Goss. First, I'll point out that the Clardy appellants have not raised this as an issue. And that line of cases which address Article 4, Part 3, Section 16 are distinguishable. As an initial matter, I think the constitutional provisions are vastly different. Article 4, Part 3, Section 16 addresses the effective date of legislation, including when a law can become effective immediately upon passage. To become effective immediately, the Constitution requires that the facts of the emergency shall be stated in the law's preamble. The legislature shall have passed the law by a 2/3 vote of each house. The bill shall include such measures as are immediately necessary to maintain public peace, health, or safety, and shall not include certain measures, such as the infringement of municipal home rule. Those are all mandatory requirements. But that's quite different from Article 5, Part 1, Section 13. It's entirely discretionary. The governor may convene the legislature upon an extraordinary occasion, but she isn't required to do so. The governor also does not need to announce any facts that constitute an extraordinary occasion when exercising her authority, or prescribe the particular method by which she will determine what constitutes an extraordinary occasion, or the method by which she is going to notify the legislature.
So what you're saying is under Article 5, if I'm following what you're saying, Article 5, Part 1, Section 13, the governor can call a special session simply by saying it's an extraordinary occasion without specifying anything beyond that.
Yes, and that has happened. There's a footnote in our brief that is an example of a special session being declared without, or being convened without even a statement that the circumstance is qualified as an extraordinary occasion.
But at a minimum, at least if there's a statement that it is an extraordinary occasion, even if the governor doesn't specify what or how or anything else, that would be sufficient, in your view, under Article 5, Part 1, Section 13, to convene that special section and would not be subject to judicial review.
Yes, I think I followed that. Yes.
Okay.
And the proclamation here did specify that it was an extraordinary occasion.
It did, but it doesn't. The particular provision of the Constitution, as compared to Article 4, Part 3, Section 16, does not require that the proclamation states so, or that it even be a proclamation.
Can I ask you a slightly different question? Can you touch on the difference between legislative immunity from suit and the unreviewability of something because under separation of powers because it's committed to a particular branch?
So there's certainly, I would say,
I understand there's sort of lines of cases, but I'm struggling a little bit and I'm looking for help to understand the difference.
They're two sides of the same coin, I would say. And they are definitely, they are two lines of different cases, two sides of the same coin. I think they both serve the purpose of ensuring that that there isn't an intrusion by one branch of government into the legitimate activity of the other branch of government. On the legislative immunity side, that means that when legislators or executive branch officials or judicial branch officials, when they are acting in a legislative capacity, aren't subject to suit for that conduct that is legislative in nature. It turns on the conduct in question and not the identity of the actor. So for example, the governor, when she vetoes a bill, that is a legislative act that is entitled to legislative immunity. In the case Supreme Court of Virginia, the Supreme Court case of Supreme Court of Virginia, that involved legislative conduct by the state Supreme Court. So it's whether or not the conduct is legislative in nature, and that is when the privilege or the immunity attaches to protect those particular actions. The separation of powers is similar.
Thank you. That was a very good explanation.
Thank you.
Well, let me ask you, since I think we have a little time for me to ask this question, about the last argument in your brief about how you don't think this is a viable. You cannot use a declaratory judgment action. And I want to make sure I understand this argument. Are you really saying that if someone thinks that a governmental action, like a statute or something else, is unconstitutional, that they cannot challenge that under the Declaratory Judgment Act? Are you really saying that?
It depends. This court has said that the Declaratory Judgment Act does not create a cause of action. It simply provides a more flexible remedy to parties that is ancillary to some other cause of action, such as a quiet title action or perhaps an administrative appeal.
Okay, so there's a statute that's enacted that says black people can't buy real property in the state of Maine. They can't file a declaratory judgment action saying that statute is unconstitutional under state law?
So I think that there could be a circumstance where an individual could file an anticipatory challenge to challenging that particular statute. That would be under the circumstances where there was an individual, who was trying to buy property, and if they did so, they would be subject to prosecution under the statute. In those circumstances, you don't have to wait to be prosecuted in order to raise the defense that this law is unconstitutional. Those are the circumstances that were identified.
But something like this, if somebody really thinks it's unconstitutional, they don't have a right to seek judicial redress.
Not these.
Assuming standing.
Yes.
It's tied to standing, I think, isn't it? Isn't it tied to standing? They have to have suffered a cognizable injury?
Yes, correct. Yes. So whatever the cause of action is, there still has to be some sort of injury that is alleged, and that individual has to either perhaps be threatened with prosecution, or there could be a planned action by a municipal board that then the declaratory judgment action can be utilized. But again, there is another cause of action out there. There is either a potential prosecution, or there is another potential administrative appeal, or the quiet title action, and the declaratory judgment action fills the gap. I apologize.
No, thank you, counsel. Mr. Woock.
I want to touch on is following the questions of the court as to whether this court can define the scope of other constitutional powers. The court mentioned Morris v. Goss, where the court defined the scope of another branch's authority. There are also instances where the court has enforced the exclusivity of a branch's authority at the expense of another branch's, as seen in Hunter versus State. And there are also consequences where one branch's interpretation of the Constitution may be at odds with the proper interpretation of the Constitution, and the court steps in and clarifies the scope or the meaning of a potentially ambiguous constitutional provision.
Let me ask you a question about extraordinary circumstances.
Sure.
Extraordinary, extraordinary means outside the usual or outside the ordinary, does it not?
I agree with that definition.
Well, is it typical and usual for the legislature to adjourn without completing all of the business at hand?
Absolutely, Your Honor.
It's typical?
Yes.
Then, well, bills are carried over, yes.
Yeah.
But is it typical for them to not make appointments and so forth?
Well, and that gets into a slightly nuanced issue where the governor can convene one of the legislative bodies in order to have appointments heard, and that's actually in a separate section of the Constitution. That power is there, and it's not conditioned at all. So, when the governor invokes the extraordinary occasion of needing to confirm appointments, that is another example of kind of the pretext of the situation.
Counsel, you led off by saying you were asking for a couple of forms of ordinary relief. Your complaint is asking in the prayer for relief in paragraph D that SB 594 remain in effect and all matters not finally disposed of at the time of adjournment, sine die, are to remain held over in a posture in which they were at the time of adjournment. That's pretty extraordinary, isn't it?
The relief in this context, Your Honor, is for the order to be vacated and remanded with instructions as to how the Superior Court can interpret the extraordinary occasions power consistent with framework that could be provided by this court, and also address the legislative activity issue. In the context of the complaint, though, very briefly, it's effectively a remedy sought where there's not an adequate quorum of legislature and bills are being passed and enacted without proper constitutional quorum.
Thank you.
Thank you, Your Honor.
All right, thank you, counsel. Thank you for your arguments here today. We will, as is our usual practice, be issuing a decision in due course in writing. And with that, I believe we are in recess for the day.